Good afternoon, everyone, and welcome to today's webinar. I'm just watching the attendees list. I'm just going to give everybody another minute for this list to grow a little bit more on my end. So yes, good afternoon, everyone. I'm Masterclass Ramdas, and I'll be your host for the session from LexisNexis. Today, our webinar is based on understanding when applications should be followed and when there's an action proceeding in civil litigation also. So this webinar is designed to provide you with the practical insights that you would need and you can apply to mastering the success of your case before you. So before we begin this afternoon, I'd like to mention that this is the first session in what we hope to have many more follow-up sessions as we progress, because this is quite a broad topic and made up with a lot of practical insight as well. And we will probably have many follow-up sessions, so soon to come webinars as well, where we'll explore further topics such as your opposing applications and your drafting affidavits in greater details. But this afternoon, I am glad and happy to be on this panel with the panel before me. So I'm going to introduce our panelists, and you can see them on screen. We have Advocate Liesel Haupt, our senior counsel, and she brings with her 25 years of experience in her field. And we have Advocate Helen Fourie, also senior counsel, and she brings 29 years of experience. So you know we are definitely in good hands, combined experience. I'm definitely going to learn a lot as we go along. So together, they co-author the title High Court Motion Procedure, a practical guide, which is also which is written with Judge, I'm going to try and pronounce it, Nierka, and that will be showcased during our session. So during this webinar, we are going to also be showcasing our Lexis Plus South Africa platform, which is developed on modern technology to assist us with such topics that we're going to be discussing today. It helps us to see the reliable and innovative platform that we have before us. As we said, we have reliable content, but the way we deliver that content in terms of your research needs also needs to be at your fingertips. So as we move through this webinar, I'll be showcasing the platform. You'll be seeing my screen being shared while our esteemed panelists talk about the respective pieces of civil litigation. There will also be a pop-up on your screen throughout the webinar regarding the product itself. Please complete this poll if you would like to find out how you can utilize the tool for yourself. And as we go through this webinar, please, you're more than welcome to post a Q&A, and we will try and answer that at the end of the session. So with no more hold up, I'm going to hand it over to Advocate Haupt and Fourie to get us started on today's webinar.
Thanks, Ashleka, and good afternoon to all the participants from me, Liesel Haupt. Thank you for sharing your time this afternoon with us so that we can just take you on a journey with regards to motion court proceedings. Obviously, our co-author is Judge Brenda Neukircher from the Gauteng division here in Pretoria. Now, to start off with, for you to fully understand application proceedings, you must understand what process you need to follow. And there are two processes. The one is obviously action procedure, and the other one is the application or motion procedure that we will start with for today's session. The main difference between the procedure, and which should be your guidance when you have to advise a client and decide which manner you're going to approach the court, is going to be to look at the manner in which the evidence is going to be placed before the court. Now, if we have our action proceedings, we know that starts off with a summons that's issued. You've got your particulars of claim. The person who claims is the plaintiff. The person who defends is the defendant. And with action proceedings, the evidence is placed before the court viva voce. So you have your physical witnesses coming to court, being sworn in before the presiding officer, and then giving their evidence in chief, obviously no leading questions, cross-examination, very important. Remember in your cross-examination to put your client's version to that witness. Go and have a look at the Constitutional Court judgment of President of South Africa versus SAFU, and you'll get all those guidelines so that you don't run into a difficulty when you do take the action process, but you haven't properly put your case and your witnesses' versions to the version of the other party. Obviously, after cross-examination, it is then an opportunity to re-examine the witness as well. Always remember, the shorter the re-examination, the better. And because of the manner in which the evidence is placed before the court in action procedure, a lot of it revolves around the credibility and the reliability of the testimony before the court. And the presiding officer is going to determine at the end of the matter, having regard obviously to the evidence being put before, not only the viva voce evidence, but also the documentary evidence or expert reports or photographs or reports, other reports that have all been obviously testified about by the relevant witnesses. And the presiding officer is then going to evaluate that evidence, and it includes sometimes the demeanor also of the witness, and make some kind of a credibility finding with regards to the reliability of the evidence before the court. Have a look there at your Stellenbosch Farmers Winery matter. It's a SCA matter. Paragraph 5 of that judgment is a very, very good judgment to see how, especially in trial proceedings or action proceedings, how the court weighs up the evidence when the court is confronted with two conflicting versions. The manner in which you proceed by way of your summons and your particulars of claim or your counterclaim and your plea is you only put the material facts before the court to substantiate the relief that you are seeking. So if Ashleka can just bring up, for instance, one of the publications that's really a staple for any practitioner, young or old, and that's Ambler's Precedents of Pleadings. So that if you look at that, and when I start discussing the difference between application proceedings, you will understand what I mean, especially if you are more of a younger practitioner that's just starting out now. So always remember, in action proceedings, it is the facta probanda that is pleaded. In other words, the facts that you need to prove your claim. So, Ashleka, if you can just call up, what are we going to look at here? Just get us any claim that we have in Ambler's, for instance. Right. So you should see on your if we can just go down a bit. Thank you so much. If we, for instance, just go down to the precedent, please, Ashleka. You will see, for instance, if you look at Ambler's and your specific claim, your claim will be very, very concisely put. So in other words, you will not be pleading any evidence. In other words, the facts that you need to prove the facta probanda, right? That evidence. And that is what we refer to as the facta probantia. Now, application proceedings is totally different. Application proceedings, you place your evidence before court, not viva voce, but through a written document, which is under oath, and what we refer to as an affidavit. And in that affidavit, you are going to put in your facta probanda as well as your facta probantia. And that is a big difference between the two processes. It's very, very important that, and we will deal with that shortly when we come to the notice of motion and the founding affidavit, if you are the applicant, is that you must, before putting pen to paper and drafting your notice of motion and your founding affidavit, that you must do proper preparation to know, firstly, what your relief is and what you need to put into that affidavit. Very important is that, especially those of you, and I'm speaking more to the attorneys here who are automatic commissioners of oath. Please, attorneys, you know, a very unhealthy thing has started to develop, and I think it's not something new, it's just actually unfortunately become worse, is that affidavits that are supposed to be confirmed under oath in the presence before the commissioner of oath is sometimes done without that party being present. You're quickly doing a favor for a colleague. No, don't do that. Remember, we are part of the greater legal system. The presiding officers count on us as officers of the court, and whether you appear before the court or whether you draft papers or whether you assist the court as a commissioner of oaths, to protect the integrity of the whole process, and particularly with application proceedings. It is very, very important to protect that integrity by making sure that the presiding officer who has that affidavit in front of him knows that this person confirmed it under oath before the commissioner. And if I call that commissioner will confirm. Because remember, the presiding officer doesn't have the same opportunity than the presiding officer will have in an action proceeding where you physically see the witness before you and the registrar or the clerk swears in the witness. So that's very, very important. What is the difficulty if you do not choose or don't acknowledge the difference between an action or an application process? Obviously, it's you run the risk of your matter either being struck because there's a dispute of fact that cannot be resolved on the papers, or your matter can simply just be dismissed, and obviously with that cost implication as well. So Helen is going to deal a bit further with when application proceedings are appropriate and when there is guidelines from the legislator in that regard as well.
Right. Now, I always prefer to bring a motion proceedings or application proceedings, and I think a lot of people do, because there are three obvious benefits to your client. The first benefit is that, as a general rule, it's less expensive to obtain relief by way of motion proceedings than it is going through the entire action and trial process. And of course, you also get a more expeditious or speedy resolution to the dispute between the parties. But for those of us who go to court and who manage the matter, what's really nice about motion proceedings is that it's a contained environment and you have control over the proceedings. You don't have to deal with a panicking witness who comes up with a whole new version when they're under oath in the witness box. But because there are benefits doesn't necessarily mean that you're entitled or you're able to use the motion proceedings or application proceedings at will. The basic, you have to consider two tests. It's either appropriate and permissible or it's impermissible. And the overriding consideration when calling that judgment, deciding whether it's going to be appropriate or impermissible, is the question of whether the material facts on which your client or the applicant relies for relief, whether they're common cause or whether you anticipate a dispute of fact arising. And the locus classicus that you always need to look at as a starting point is the case of Room Hire Company and Jeppe Street Mansions. Now, I see there's been a request for us to repeat the names of the cases, but we'll put all the names with the full references of the cases in the comment box later when we're almost at the end of our presentation. So that's the first issue, is whether there's going to be a material dispute of fact or not. But remember that statute also does play a role. Dispute of fact is not the only consideration. Now, I'd like to look first at those instances when it's impermissible to use motion proceedings. And the first, of course, is when you anticipate a material dispute of fact. But other instances would be if you rely on allegations of fraud, because you cannot prove fraud on affidavit. Defamation is also excluded from motion proceedings. The Divorce Act pertinently refers to divorce actions, so divorce cannot be obtained on motion proceedings. And then lastly, of course, a claim for unliquidated damages. Those are all excluded from motion proceedings. When would it be appropriate to go to court on motion proceedings? Well, if the material facts are common cause and the court simply has to determine a legal question, that would be the ideal situation. Urgent applications are allowed more leniency, and at least one can obtain interim relief, if not final relief, in urgent applications. Then applications which do not commence proceedings, which are of a more procedural nature, are also form a separate category. Those often fall under Rule 6 sub 11, which deals with interlocutory applications, although a lot of applications that are provided for in the Uniform Rules of Court do not fall under Rule 611. And an example would be a default judgment under Rule 31, or an application for summary judgment under Rule 32. Then there's, of course, Rule 43 for interim maintenance, contact and care of minor children. It's possible to bring an application under Rule 46, Rule 46A for execution of immovable property as a substantive application. And then Rule 53 forms the basis of your review application. Insolvency matters have also been established as the kind of matters that may, as a rule, be brought on motion proceedings. So that's a list of all the matters which you can use to decide whether it would be appropriate to bring a motion proceedings. And remember that applications and actions often walk hand in hand. They're not necessarily mutually exclusive. So while you may have instituted action for relief, that same action may finally be resolved by way of an application for default judgment. So keep an open mind and make sure that you get to know your Uniform Rules of Court if you're practicing in the High Court, and if you're practicing in the Magistrates Court, you need to know the rules and the Act. Liesel is now going to take you a little bit further down the road with a roadmap to getting the show on the road, so to speak.
Thanks, Helen. So now after you've considered the guidelines that Helen has now given, and you've taken the decision, well, your particular matter for your client, the appropriate route is then application proceedings. Your roadmap or your GPS for your whole procedure, you will find in your rules, either in your Magistrates Court rules or in your High Court rules. And those rules obviously can also indicate to you in specific circumstances what specific requirements you have to meet. For instance, Helen referred to default judgments. There's a particular rule dealing with that. Summary judgments, you've got a rule in your High Court as well as in your Magistrates Court rule dealing with that. Rule 43s, we've spoken about interim relief pending a divorce. In the High Court, it's your Rule 58 in your Magistrates Court. And curator ad litem's, to appoint a curator ad litem. We're not talking about children now, for a patient specifically. The appointment of a curator ad litem or a curator persona or a curator bonus is specifically regulated by Rule 57 in the High Court. So start off with your rule. For instance, if you look at High Court Rule 6, you'll find that High Court Rule 6 specifies that it's 3 affidavits that you can file: a founding, answering, and an opposing affidavit. Rule 6, I think it's 6.5D, if I recall correctly, also refers to the court exercising its discretion for further affidavits, but you cannot just exercise that as a right. You need the condonation of the court and the permission of the court. Rule 6 also deals with your ex parte applications, where there's no notice for whatever reason to the respondent. Rule 6.12 deals with your urgent application, stating very specifically what requirements you need to make there. And then also Rules 6.15, for instance, states where a court can, on application, strike out irrelevant or vexatious or scandalous references or matter from an affidavit. Remember, to every general rule, there's also always an exception. And obviously, once again, Rule 43, for instance, is an exception to the general rule of the 3 affidavits. Rule 43 is 2 affidavits. We know about the full court decision in E versus E in Gauteng, but obviously that was on the specific facts before the court, but obviously the rule in itself has not changed. So a party is not entitled by right to file a replying affidavit because the rule simply doesn't make provision for it. And secondly, also, and that's just a portion from our book from chapter 3, where we deal with the family-related matters, for instance. And you'll see, for instance, that rule is it's self-contained. It deals specifically with 4 elements. It's the maintenance, then you deal with care and contact of children, and then contribution towards costs. So if you want to file further affidavits in terms of Rule 43, you will have to either make out a case in terms of 43.5, but once again, not as a right. So go to your rules, make sure that you understand the applicable rule to your application before you start. And obviously, before you start consulting and drafting, attorneys, very important, always just lay the table for the application by writing a letter to the respondent, seeking some other undertaking, or requesting a roundtable to see whether you cannot resolve the dispute in a non-confrontational manner. Because you can attach that letter at the end of the day to your affidavit. It might assist you with costs, but it also will assist you, obviously, in terms of Rule 41A, where we have to now file, whether it's action or application proceedings, you have to file a notice to say that, you know, either you're amenable to mediation or you're not, and you must state the reason for that. So very, very important. Because there's only the set of affidavits, the 3 affidavits, in application proceedings, you stand and fall by the papers filed. So either it's in there or it's not in there. You cannot amend a founding affidavit. You can try and maybe, I don't know, soften the blow in the replying affidavit, if you want to be so bold because you've forgotten to address something in your founding affidavit. But you do that at your own peril, because the authorities are very clear that a case must be made out in the founding affidavit. Only something that you could not have anticipated, for instance, would have been raised. Can you then address as something new in your replying affidavit? Very important as well is that the person who is going to draft the affidavit is the person who must consult with the relevant witnesses, right? So remember, you might have more than one witness. So you're going to have either your applicant or your deponent on behalf of the applicant, if it's a juristic entity. But you might also need some confirmatory affidavits from other witnesses, right, who can confirm a certain version of events, or something else that's relevant to the relief that you are seeking, because in your affidavit, you will have to tell your story to the court, so that the court, as well as the person who has to answer to this application, understands what you want and why you want it, right? And to get to the what and the why, you need to engage with the evidence during your consultation. You must also, during your consultation, anticipate any possible arguments or points in limine that may be raised, something like, for instance, as locus standi of the applicant, or, for instance, jurisdiction, or maybe there's an arbitration clause that's applicable, or a certain mediation clause that you have to follow before coming to court. But you must also anticipate to address the shortcomings. So just a phrase that I always keep in my mind when I consult and just before I start drafting is think before you ink. It's applicable when you want to get a tattoo because of the permanency thereof, but it's also very applicable when you draft an affidavit, because once that affidavit is drafted, it's signed by the deponent and it's been served and filed, you have to stand and fall by that. So think before you ink, please, and before you do your affidavit. Very also important, you must, whilst gathering your information, make sure that you got all your evidence to back up the relief that you are seeking. For instance, in a Rule 43, salary of a person is very important for income. If you look at a maintenance claim, for instance, or if you want a contribution towards cost, your pro forma account. All right. Also have a look at your practice directives, because some divisions have got certain practice directives that have to be complied with for particular applications. In Gauteng, for instance, to use the Rule 43 example again, we need to comply with the filing of a financial disclosure form. And that's very important, obviously, before you start drafting, to know what's in that financial disclosure form of your client. So, right, so now you've started with your consultation, you've consulted with your client, you've got your information. And what is the next step, Helen?
Right, your notice of motion. It's a good idea to start off drafting your notice of motion before you start with your affidavit, because it does set the scene. Very often it's something that will only be finalized at the end. But a notice of motion is an important document. It's not a mere formality. And I want to warn you against simply asking your secretary to draw up the notice of motion. We've all done that, and we've all run into trouble. Why do I say a notice of motion is such an important document? First of all, it's the document that initiates the proceedings. It advises the court and the respondent of the relief that the applicant seeks. It advises the respondent what the respondent is to do and when he or she is to do so, when a notice of opposition is necessary and where that must be delivered. So it's important to ensure that the correct court is identified and the correct address of the court is identified. The same applies to the attorneys on record for the applicant. Make sure that it's a proper address in terms of the rule and the respondent knows where that notice of opposition must be delivered. And finally, the notice of motion advises the respondent of the consequences of delivering or failing to deliver a notice of motion, and that is the date on which relief will be sought in court, or an order will be moved for in court. So that's why your notice of motion must be drafted accurately and properly. The form of the notice of motion depends on the type of application that you're bringing, and the correct form is also very important. You might find that your opponent delivers a notice of irregular proceedings if you've used the wrong form and the respondent is prejudiced. For example, where insufficient or no time is provided for a notice of intention to oppose. But you can also prejudice your own client if you use the incorrect form. And an example of that would be where you've brought a review application and you've used Form 2A, the normal Rule 6 form for your review application, and you haven't provided for the decision maker or administrator to deliver the record of the proceedings, and you haven't provided for the applicant to be given an opportunity to supplement the founding affidavit. You deny your own client those rights if you don't make sure that you've used the correct form. And of course, if you're not using the correct form and you're disregarding the rules, you run the risk that the judge or the magistrate will just simply be irritated with you from the outset, and that's something that you need to avoid at all costs. Now, when looking at the type of forms to be used, there are three main types, and then there are some specialized types. So I'm going to look at the three main types first and explain each one of them: your short, your long, and your interlocutory, and then I'll have a quick look at some of the more specialized types. So we all know the short form. In the magistrate's court, that's Form 1, and in the High Court, it's Form 2, and it's used in ex parte applications. Now, an ex parte application is appropriate when it's unnecessary to give notice. Now, it's unnecessary to give notice in circumstances where there isn't another party whose rights will be affected by the relief that you seek. Now, although there may be no party whose rights are affected, there may still be parties who have an interest in the relief that you seek and may still require notice of the application, but they're not cited as parties, and you can use the short form. An example of that would be an application to change a marital regime or an application for admission as a legal practitioner. The Legal Practice Council has an interest in your application for admission, but they don't have any rights. They have no right to be cited as a party. If the Legal Practice Council wants to oppose your application for admission, they must intervene. So that's when it's unnecessary to give notice in the sense of a party being entitled to participate in the proceedings. The second instance where it's appropriate to use ex parte applications would be when there is good reason not to give notice. Now, there may well be another interested party, but the circumstances justify not giving them notice at the time. That may be because of reasons of extreme urgency, and you would have to make out a very good case, and you would probably only get interim relief, but certain instances of extreme urgency may justify an ex parte application. Also, when service of the application would undermine the purpose for which the application is brought, for example, an Anton Pillow order or a Morava injunction, when there is a real fear that evidence may be destroyed if the other party were to have notice of the relief that is being sought. The third instance is when you are seeking preliminary relief to main relief. For example, an application to appoint a curator ad litem to investigate whether it is necessary to appoint a curator bonus for a patient. Ashleika, could I ask you perhaps just to keep the screen quiet? It's moving up and down, and I think it might be distracting people. And we don't need it right now. I'd really appreciate that. Thanks. Sorry about that, Ashleika. Right, so preliminary relief to the main relief, I've told you about the appointment of a curator, and the other instance would be, for example, an application for substituted service prior to instituting a divorce action. And the fourth and final example I'd like to give you is where the legislator has provided a right. For example, an application for an interim protection order allows you to bring an ex parte application, which is then in due course, of course, served on the respondent. So those are the main instances in which an ex parte application would be appropriate. But do remember, and I want to mention this right now, your duty of the utmost good faith to the court when you are bringing an ex parte application, to ensure that you advise the court of all the facts, including the facts that and the law that may be adverse to your case. Now, the second main type of form is the long form, Form 2A, or Form 1A in the Magistrates Court. This is when your application is brought on notice to another party. It's a substantive application. Other parties may be parties against whom an order is sought to be made. Some parties may be cited because they have an interest, and the master is usually cited in that manner. And you may have respondents who are cited either because relief is sought against them, and then those respondents who are sought because they have an interest, but no relief is sought against them. And it's usually one specifies that in your founding affidavit, when you're describing the parties and their interest, you do advise the court and the parties themselves that those specific parties are only being sought as they may have an interest, such as the master, the registrar of deeds, and perhaps even heirs in an application that deals with a will, for example. Other examples of applications brought on the long form would be sequestration and liquidation applications, unless, of course, it's a voluntary surrender or the company itself is the applicant for its own liquidation. An application to strike a legal practitioner from the role, an application for declaratory relief, to make a settlement, an order of court, are all examples where there may be a dispute where another party's rights are affected and where you would bring a substantive application. The last instance is the interlocutory application. This is usually interim or procedural in nature, and it's related to the main substantive application or action. Generally, the relevant rule is Rule 611 in the Uniform Rules of Court, although that's not the only rule. It's a good starting point. The kind of application that you would bring in terms of Rule 611 would be an application to compel compliance with the rules of court, such as to compel discovery, or where you seek a condonation, for example, an application to uplift a notice of bar or to extend a time period in terms of Rule 27. Rule 611 does not provide for any specific form, and it doesn't provide any specific time periods. So you have to draw that up yourself, and it's very much based on Rule 2, the Form 2, the ex parte form. But you must always anticipate opposition and make sure that there are reasonable time periods provided for, that you are complying with the rules of court, whether they have to be 5 days, service 5 days before the matter is heard, for example, and of course, always take into account the local practice directives when you customize your notice of motion. The other more specialized variations of notices of motion would be a Rule 43, which is a self-contained rule. Rule 43 has a form, it's Form 17. And what's important about Form 17 is it doesn't provide for a respondent to give notice of intention to oppose. So a respondent has no right to deliver a notice of intention to oppose, and in that way to buy time for preparation of the opposing affidavit. So remember that, and don't let your time be done in. An urgent application doesn't have its own specified form, but depending on the nature of the application, you'd use Form 2 or Form 2A, but you customize your notice of motion because you adjust the time periods and you also select the date for set down. Make sure that you include a prayer for condonation for your non-compliance with the rules pertaining to service and time periods. And that is provided for in Rule 612, and it's customary to pray for that first and ask the court for that condonation before you move on to your substantive prayers in an urgent application. Rule 46A, execution of immovable property. The respondent's attention must be drawn to Rule 26 sub 1 of the Constitution. It's important that must appear in the notice of motion if you're bringing a substantive application. It's not good enough simply to include that in your founding affidavit. And then last of all, Rule 53, I've already referred to the requirement or the opportunity to call on the decision maker to deliver the record, and then to provide a time frame for the applicant to supplement its founding affidavit. So make sure that you incorporate those provisions in your Form 2A notice of motion. Those are the specialized notices. I'm sure that there are a few others, but those are the ones that you're most likely to have to encounter in your practice. Time periods, I've referred to time periods a number of times. I just want to make a couple of points relating to time periods. The first tip is use the format of the form that you have selected or the form that you're obliged to use, because that already tells you exactly what the time periods are. Don't change that, stick to that. Urgent application, select your own time, but make sure that they're attainable for yourself. It doesn't help to provide too little time between delivery of the answering affidavit and the matter being set down or the roll closing and you're unable to deliver a replying affidavit. Make sure that you can do that. Always follow the local practice directives. And then finally, if the state is a respondent in your application, Rule 613 of the Uniform Rules of Court provides that the state is entitled to 15 days and not only 10 days. Then lastly, before I hand over to Liesl again, your notice of motion is always addressed to the registrar, but it's also addressed to the respondent and, if applicable, to the other parties which have an interest, such as the master or the registrar of deeds. Shleka, could I ask you to put on the screen the section on liquidations, please? Now, in liquidations, section 346 sub 4 sub A and 346 sub 4A of the Companies Act provide or require service of the application on the master, the receiver of revenue. You can just scroll down a little bit more to page, I think it's 5.7, 17. Yes, keep going. It's page 517. All right, there we go. Under the heading General Service Application. Right. So you have to serve on the master, the receiver of revenue, the employer, the employees, and the trade unions. And there are similar provisions in the Insolvency Act relating to sequestrations. They're not parties, but they're entitled to notice. And if you are giving them notice, it's practice to address the notice of motion to those parties who will be receiving notice. And the receiver of revenue and the master, who will probably receive notice by hand delivery, can then indicate the receipt of the notice of motion on the original itself. That's not what happens when the sheriff serves and you have the sheriff's return of service, but it's a nice way to have a checklist so that you and your instructing attorney know who must have notice and whether all the parties who are required to receive notice do in fact receive notice. And in the book, we have, in respect of most of the applications, and particularly the more specialized applications under the heading service, indicated who ought to have received service of the application. And those are the parties who have an interest. And reference is then made to them in the notice of motion, as well as, of course, in the founding affidavit. I'm not going to ask you to call up the admissions, Ashleigh. I'm just going to tell the people about it. But the admissions of advocates and attorneys is another example that I wanted to share with you, where there's a statutory obligation to give notice to the local bar if it's an advocate, and to the Provincial Legal Practice Council office in both cases. And therefore, the notice of motion must be addressed to them too. The manner of service will depend on whether you're initiating proceedings, what the statute requires, and what the interest of the parties are. What makes a notice of motion a little bit different and more interesting than a summons is that your notice of motion does not have to be issued before it is served, unlike a summons. And that sometimes helps when you're a little pressed for time. Attached to your notice of motion, your founding affidavit and the annexes there too, and Liesel's going to tell you more about the founding affidavit.
Thanks, Helen. Yeah, Ashleigh, can you please just go to chapter 1 of our book, chapter 1.19, with regards to curatorship, Rule 57, so that we can just show the participants from a practical point of view, precisely, for instance, what will be in your notice of motion, and then we will deal with the affidavit, because it's very important. The notice of motion and the founding affidavit are Siamese twins. The one can't survive without the other. They share the same brain, they share the same heart, they share the same lungs. So it's very, very important that they speak to each other. Can we just go down a bit, please, till the end of that specific chapter, where you'll see, for instance, in each of our chapters, and when we deal with specific applications, the relief sought in the notice of motion, for instance. Thank you. That's the correct. So therefore, for instance, this is now for the appointment of a curator ad litem, and then after that, obviously, a curator bonus. And remember, as Helen was saying earlier, your action and your application proceedings can sometimes, walk hand in hand. For instance, if you in a RAV matter, you've spoken to the client, but later on it becomes evident that the client actually cannot make his own decisions. You get a report from an expert that says a curator should be appointed. So then you're going to follow Rule 57, and you're going to ask at your first appearance, for instance, for Pre 1, that the curator ad litem be appointed, and that Pre 2, the curator ad litem then be requested to investigate the question whether the patient should be declared incapable of managing their own affairs, and then obviously the appointment of a curator bonus. And then you're going to request the court to postpone the remainder of the pres sine die. So how is your founding affidavit going to speak then to that notice of motion? Let's quickly look at just the general principles. Again, your mantra for your affidavit is think before you ink, all right? So you must know what your relief is. You've got your notice of motion. You must make sure that you've got the necessary facta probantia as well as facta probans to substantiate the claim. In other words, facts, you need the requirements for the specific claim, but also the evidence to support that specific claim. So your general principles for your affidavits will be that it's usually in the first person, and you are going to tell your story in that affidavit. So use plain language. Don't try and be clever, because remember, your deponent must understand what they're deposing to. Your affidavit must only contain relevant and admissible evidence. So be careful here of speculation, of hearsay. Obviously, exception to the general rule is once again your urgent applications, where you can, for instance, because of the time constraints and the urgency of the matter, you might not have the opportunity to get the necessary confirmatory affidavits, and you will see condemnation for that. Be careful for vexatious, irrelevant, scandalous a matter in your affidavit itself, because it may be struck out and it can have a cost implication. Your affidavit is not something that should contain any arguments. Leave your arguments for your heads of argument at the end of the day before the matter is before the court. And obviously, when you tell your story, do it logically, chronologically, right? So if we can just go up a bit, please, Shleka, with regards to curatorship, and then we'll just see what is in the affidavit itself. Just go up a bit more, right? Just a bit more. Till it starts with the application itself, right? Just a bit more. Okay, thank you. Let's start where it starts with locus standi. Thank you. If you can just go down a bit. Right. So what we've done in our book is to try and make it a simple guideline, breaking it down in little bite-sized pieces for you. What should be, well, firstly in your notice of motion, secondly in your affidavit, and what should be in your order, and then obviously your little checklist. Just to check before your affidavit goes out that you've got everything. So you start off with the full names of your deponent, who's going to confirm the contents of the affidavit as within their personal knowledge, unless otherwise stated, and which is true and correct. Obviously, you don't need the ID of that person. The only exception is obviously if you're going to file some or other affidavit in connection with the divorce proceedings in the Gauteng division, for instance. Some of the unopposed divorces may be heard and adjudicated upon by with an affidavit confirming everything. So there you will have to confirm then your ID as well as the ID of the plaintiff, because the marriage certificate is attached to make sure that you were the people that appeared before the reverend or the pastor or whoever did the marriage ceremony. You also then have to indicate your occupation, that you major, obviously, and, you know, where's your offices or where you reside. If you are the deponent on behalf of a juristic person, for instance, you will have to indicate the authority that you have to represent the entity, and there will usually be some or other resolution taken. For instance, a company, the board of directors would have taken the resolution, and it's attached as one of the annexures, and you will refer to that in your affidavit. Why is it important to your citation as the applicant or the deponent is to vest the aspect of locus standi, why you can approach the court. So for instance, with a Rule 57, it's somebody who has a direct interest, and that can maybe be a family member, let's say the child of a person who now suffers from dementia and cannot take care of their own finances at the end of the day. You will obviously also then address who the respondent is, and this is the person against you seeking the relief. But obviously, in terms of Rule 57, you will also refer to the master and say, but you're not seeking any relief against the master, but the application will be served on the master, because that's what the rule requires. This next aspect you're going to deal with is the aspect of jurisdiction. With a Rule 57, it will be because your patient is either in a facility or still resides on their own within the jurisdiction area of the court. Next aspect, can we just a page a bit down, please, Ashleka? Thank you. The next aspect, obviously we can stop there, thank you, will, for instance, be then to just inform the court what the nature of the application is. This is an application for the appointment of a curator ad litem to investigate whether or not the patient is capable of managing his or her own affairs, and then also for the appointment of a curator personae and or a curator bonus. And this just sets the table for the judge to understand, oh, this is an application in terms of Rule 57. Then you start off by setting out your facts. In other words, it must be in a logical and a chronological manner, and you must make out your case there. For instance, with the Rule 57, you will refer to the doctors, because you need to attach 2 reports from doctors The one is usually, especially if you're working with somebody with a mental capacity, will be either a neurologist or a psychiatrist. And then, but one of the two medical professionals must be somebody that's not known to the patient. It's somebody who's just seen the patient and is reporting on the patient's condition for as far as it's relevant to the application. So their reports are going to be attached, and it's always good to attach a supporting affidavit from that particular medical practitioner. Sometimes these matters are brought on an urgent basis and you don't have time to attach a confirmatory affidavit because the doctor is in surgery for the whole day, for instance, and then you can ask the court's condonation, or you can ask that the curator ad litem follows up with that individual. And then obviously closing off, then asking with regards to the costs, why you are seeking costs in the particular matter. So that is very important. And once again, just remember, anticipate any possible arguments and already diffuse issues that might be problematic for your case in your founding affidavit. It creates a much better impression than trying to soften the blow in your replying affidavit. Remember, for instance, urgent application, you need to specifically deal with why the matter is urgent. You cannot expect the court now to, glean from reading the affidavit as a whole why it's urgent. You need to specifically address it. If you don't want to repeat certain of the factual allegations, just refer the court back, for instance, to say, I refer to what has been stated in paragraphs 3 to 25 here and above regarding the following. Okay. And then obviously after costs, say that you seek relief in terms of the appraise of the in the notice of motion, and you end off your affidavit with obviously the oath being administered by an independent commissioner of oaths. So that's all we have time for this session. If there's obviously enough interest, then we will have a separate session on what happens when the application is opposed. What are the processes to follow there? And then obviously the next session will be, but now all the papers are before court. Now we have to go and argue. What do you do with your heads of argument? What must be in your heads of argument? Your draft order, your specific practice directives. And obviously, founding affidavit, also remember, if there's a specific practice directive you need to adhere to in your division that needs some clarification or amplification in your founding affidavit, then you do that. Ashleka, can I please just ask you just to scroll down to the end of this chapter? At the end of each chapter, for instance, we then, so there we've gone the notice, relief in the notice of motion, just to the end, please, Ashleka, just go down. And at the end of each chapter, we have a little checklist, which seems to be missing now on this platform, but I do promise you it is in the publication, where you just check yourself that you've made the necessary vehemence and you've attached the necessary documents, and then you can just check that off for yourself before obviously serving your application. Right. Don't know, do we have any time for questions?
So Advocate Hub, Advocate Fareed, what an insightful session. I'm sure many of our listeners have gained a lot of knowledge and guidance from all the guidance here. I'm sure we are definitely going to have follow-up sessions. There are many Q&As that are coming through. Unfortunately, we don't have time to answer all of these. Okay. So what we propose is that we will forward these and try and get them in a written reply in terms of a communication that can go out to our participants as well with the follow-up sessions. Yeah. With that said, thank you so much for your time. users you're probably seeing a poll up on your screen. If you are interested to get more information on Lexis Plus South Africa, please click yes or no, and we'll get one of our consultants to contact you. But with that said, and with all the discussion that's happened this afternoon, and to start getting us a head start in terms of research, as I said at the beginning of the session, this is Lexis Plus South Africa that you're seeing on my screen. As we've been hearing this afternoon, in terms of research, as practitioners and researchers, we are very interested to understand how we use our application proceedings as well as our action proceedings in our civil litigation. So just to showcase, you have seen me showcasing navigation quite strongly on the system. But if you had to use the system in terms of research and trying to pinpoint the specific rules and questions or guidance that you're looking for, that Advocate Haupt and Fourie have been talking along. And I'm going to use some of those catchwords in terms of these searches here to show you the power and strength of Lexis Plus in guiding you to that information on the platform. So if I came into the system and I was very interested in high court motion, like we've been hearing this afternoon, and I have the opportunity to now see that content. We have content available across all these different content types, but I'm very interested, besides case law as a practitioner or researcher, I am very interested in looking up what these application proceedings look like. So I'm understanding as a practitioner that this will probably guide me more into the angle of an analytical material besides the case law that you're seeing on my screen on the right-hand side. I would to be guided to a commentary set. So I'd want to refine my research as I go through. Very interestingly, because of the search words that I've put in, we've seen also, besides talking about high court motion procedure and recommended as a text as well across litigation, is litigation skills for South African lawyers that are coming up on my screen. So you can see the system is triggering what's available. So if I had to refine my search in terms of commentary sets that are available, I can also scroll further down. I can look in a publication title, and that will give me a range of publications. And like we've been hearing, litigation skills, high court motion procedure being highlighted through the discussion in the webinar this afternoon. So I'm going to click on high court motion procedure, and you can see as we've been reflecting on urgent applications and so forth, that's also coming through. But what's interesting about Lexis Plus is that from this part of research, I can also refine this. So I'm very interested in looking at urgent applications and what further information that might come up in high court motion. So I'm going to refine my search, and now you're going to see quite a graphical view, a more colorful view in terms of the catchwords we've been using for search. So this graphical view on my screen is guiding me as to the concentration of my search. So I'm picking up exactly what I'm looking for. It's directing me directly to a chapter. If I click on, I will be able to get into the chapter itself, and as highlighted, urgent applications being a point of discussion, that's giving me all the keywords in terms of what I'm looking for, directing me to look at the document type itself. When I click on off the table of contents, which you've been seeing me demo throughout the session, you can see now I've got a little navigation bar here as well, and that's giving me quite a concentration of the search. As I hover over, this is also helping me and highlighting the information that might be required in terms of my research. It's interesting that the document is telling me there's motion and it's urgent here. I'm very interested in urgent applications, so I'd want to click on the specific keywords and look into where that concentration is, and also directing more to the case law as well, like both our advocates have been mentioning. When we have references to case law or statute law, that has been linked quite effectively. So that's bringing to the forefront of how Lexis Plus South Africa can help you in terms of what you're looking for. Like I said, you can also direct your searches directly to what you're looking for on the platform. Besides using all the filtering that we have on the system, we also have functionality around your folders, so you can save your research in terms of what you're doing for the day. Come back to the trail of maybe tomorrow you get in and you want to know, where did I stop in High Court motion? This will give you not only a trail of searches and documents, but it also allows us to look at a research map. And a research map gives us a trail of how I'm following my research. And that's helping you to put together your research for your specific information around your case. With Lexis Plus South Africa, we've also housed practical guidance as the next solution on the platform besides using legal research, and that's also applicable in terms of the research practice area you're looking at. To tie in with the webinar this afternoon, we've had civil litigation spoken about, so you've also got opportunity to look through our practice areas that are available, civil procedure being highlighted here on my screen as also a practical tool to bring to your legal research. So reach out to us via the poll, and we will definitely get a sales agent or a trainer to get in contact with you to give you more information or request a quote as well. Thank you, Advocate Haupt Fourie. We will definitely be looking forward to further sessions with you. Thank you everyone for joining us this afternoon, and take care. See you soon.
Thank you, everybody.
It's been a
Bye.
pleasure.
Bye.
Bye.